So today on the agenda, our first bill is Senate File 811 from Senator Laurie. Senator Laurie, if you just go ahead and you know the drill of, and also we'll mention that we do have quorum.
Thank you, Madam Chair and members. Yes, I have Senate File 811 before you, and this is a pretty simple, straightforward bill to include Minnesota Tribal Council members among the type of government elected officials for which individuals are offered a unpaid leave of absence protection. This protection exists currently for legislators, city councilors, county board members and whatnot, and we're extending this unpaid leave of absence to individuals serving as an Indian Tribal Council member. I have Reed LeBeau here to answer any questions, if there are any. Did you wish to offer testimony or just stand for questions?
Okay, thank you, Senator Laurie. Questions from any members? Well, it's a pretty straightforward, simple bill, Senator Laurie. So thank you very much for coming, and this bill will be laid over for possible inclusion. All right, thank you.
Okay, thank you, Madam Chair and members.
All right, here I go.
Next on the agenda, we have Senate File 1225. Senator Kiffmeyer.
Thank you, Mr. Chairman, members of the committee. Senate File 1225 has to do with voter challenges. As we know, in both the Minnesota Constitution and in statute, there are certain voters that are not eligible to vote, nor shall they, as the Constitution says, nor shall they be permitted to vote. So it is a matter of eligibility, but it is also a matter of administrative process to make sure that they are not permitted to vote. And so the bill today that we have is taking an administrative approach, again, as we've done, and we have done, dealt with these voter challenges before. And as technology has increased, what used to be done by paper now is done with digital records and working together with systems like the Department of Corrections, the courts, Department of Public Safety Motor Vehicle Services Division. And so in this particular bill, the sections as we go through that consolidates reporting requirements on reports received from the court administrator, Department of Corrections, Department of Public Safety, and notice sent to an individual who is challenged, and the individual has the opportunity to contest that provision. And members, I think this is a very, very important part. This has not been done before, where notices of challenges have gone out to our voters. And that's a very important fairness and opportunity for them to be able to have that, and also a process for them to contest that challenge. Usually this is done on Election Day in the polling place, and I think this is a much more fair process and gives them an opportunity prior to that to deal with those, and also for the election administration. It does do some technical things like updating cross-references and provides a definition of personal knowledge. The public information list indicating also the challenge status and the reason for the challenge. Reports on guardianships, legal incompetence, felony convictions, and citizenship status changes as well. And then there are report requirements submitted electronically at least monthly, and those reports must include a complete list of each individual under the reporting entity's jurisdiction, not just certain changes. The State Court Administrator report as well. And then we also go on to a very similar process, the Commissioner of Corrections and the State Court Administrator report. There's also a report regarding the restoration of the right to vote. Once people have finished all of their time, both in prison and also serving probation, and they have completed that term, and they are again eligible to vote, that restoration notice as well. Commissioner Public Safety report, notice of challenge again, contesting a challenge, registration and verification of registration by the election judge in the polling place on election day. And especially the fact that when there is a challenge on the roster, realizing that this information has come from the Department of Public Safety, it has gone through quite a process there. It comes through the courts as well, and they have legal requirements that they must meet. And then also the Department of Corrections. These are not uncertain sources just reported. These are sources that should be reliable and dependable. And as such, when we are in the polling place on election day or at any time where voting is occurring, that if there is a challenge, then they may challenge that individual based upon personal knowledge. But if that challenge is not sufficient, if the overcoming the challenge and the rationale there is not sufficient, then we want to make sure that there's every opportunity to cast a ballot. And that is where provisional ballots come in, and they are acceptable according to the Help America Vote Act. So what it lays out in Section 11 is a process by which we cast provisional ballots, the counting of them, the reconciliation, and then also the misrepresenting of an identity in the process of requesting a provisional ballot, which is also in statute and other places. Then some cross-references. And so that is the basic sum of the bill, 1225, working to increase the integrity of the process and to make sure through the use of provisional ballots that every voter entitled to a vote is able to vote. And those who are not, as the Constitution says, they're not eligible and they shall not be permitted to vote. So I believe this is a fair process with notice, with ways to contest those, an appeal process that we are able to utilize. And so the effort is to make sure that access is protected. And with that, Mr. Chair, those are my remarks at this time, and I know there are quite a few testifiers, if there are, that we would enable them to have the time.
Senator Kiffmeyer, I believe you have an author's amendment, A2.
Yes, I do have an author's amendment. Thank you very much. The A2 author's amendment.
Thank you, Senator Kiffmeyer.
I'd like to move the A2 author's amendment.
Senator Kiffmeyer moves the A2 author's amendment to Senate File 1225. All those in favor, say aye.
Aye.
Opposed? Motion passes.
And to add additional information in regards to the A2 amendment, this includes election judge party affiliation as public data. And members, I will state that who you vote for is a sacred secret, protecting that secrecy. But when it comes to election judges, the value of them in the party designation, in the polling place on election day, watching both Democrats and Republicans overlook the election process is a very valuable service to the people of Minnesota. They are that check and that balance that when you have the partisan in this particular location, the advantages to the voters in the integrity of the election process. But it is also important that what political party they belong to should be a matter of public record. Then there are some technical language things that staff have brought forward on us. And then also, for when you have paper rosters, the challenge status on a paper roster at times having the fact that you are challenged because of felon or challenged because of a ward or a guardianship issue. We've had some concerns expressed by citizens of that information. This is a methodology listing challenges 1 through challenge 6 defined here in statute, actually 1 through 8, that are defined here in statute, and that an election judge could quite readily have a little card along with them that would deal with what those are, but it helps to protect the privacy of any individual voter. And that is for only when they're using a paper polling place roster, because if you're using an e-poll book, that is not displayed then to the rest of the voters other than their own record. And then also just some other language as well. And then it does remove in Section 14 the self-certification, because now we have a process by notice and by challenges and provisional ballots to make sure that every voter who is entitled to vote is able to vote. So thank you. That is the summary of my presentation of this bill.
Thank you, Senator Kiffmeyer. Question? Senator Rest?
2 questions. One, Senator Kiffmeyer, is it your intent that the committee will take an independent vote on this bill by itself today? And then secondly, where's the fiscal note?
Senator Kiffmeyer?
Thank you very much, Mr. Chair. And no, Senator Rest, we will not be taking a vote on this bill. It would be laid over for possible inclusion and also for opportunity to work together with the stakeholders to refine the language as needed.
And with regard to the fiscal note?
And as to the fiscal note, it has been requested, and it is not that I see here. Mr. Lundin can address that.
Mr. Lundin?
Mr. Chair, and Senator Rest and Senator Kiffmeyer, the fiscal note was requested. I've gotten a preliminary one, but we have not received information back from the Department of Corrections nor the Department of Public Safety on the fiscal note.
Senator Rest?
Thank you. I certainly hope before we take any action on this part, if you're putting it in the omnibus bill, that we know how much it's going to cost.
Mr.
Senator
Chair.
Kiffmeyer?
Thank you, Mr. Chair, and absolutely agree with Senator Rest.
Thank you, Senator Kiffmeyer. It appears we have some public testimony. And so we have a total time frame of 15 minutes. It appears we have at least 5 speakers or testifiers who've spoken up. If we could start, if you could hold your comments to a minute or keep them very brief. We have a total of 15 minutes. And if we could start with Andy Seelig.
Mr. Chair, if all the testifiers want
Senator
to come
Kiffmeyer?
up to expedite
Yes.
their time, as they could
If we could
just-
have those that have signed up so far, that would be Pamela Hoops, Mark Haase, Kathy Tomich, and the Secretary of State, Steve Simon.
Mr. Chair, if you wouldn't mind if we take the Secretary of State first, if he so wishes to do.
Great. Secretary of State, Steve. Mr. Simon. All testifiers, please state your name and your organization prior to testifying.
Thank you, Mr. Chair and members. Steve Simon, Minnesota Secretary of State. I want to thank Chair Kiffmeyer as well for starting off this discussion. I want to be quick because I know you have a lot of testifiers here. There should be a letter before you talking a little bit about some of the technical concerns that we have, but I wanted to address in my testimony here in my brief time one overarching concern that we have, and that is with the imposition for the first time, we think, in the history of the state of Minnesota, of provisional balloting. We think it's particularly inappropriate in this particular circumstance and instance. And just a little bit of the history, as Chair Kiffmeyer said, the Help America Vote Act mostly required states to do provisional balloting, but Minnesota, for all the common sense reasons, was exempt at the time because we have same-day voter registration. And the way it works in most states is provisional balloting is a check intended to benefit the voter. That is to say, in most states where they don't have same-day registration, let's say you go into the polling place and you're not on the list. You know you're registered, you're sure you're registered, but you're not on the list. In Minnesota, that's not an issue. You can just register right there. But in Ohio and in California and in most states, it is an issue. So provisional balloting was conceived of as a way to allow that voter who swears that he or she registered to actually cast a provisional ballot and then go in sometime in the next, say, week or so to prove up whatever they have to prove up. This would, for the first time, create a maybe pile. Basically, it's not a no vote, it's not you can vote, it's a we're putting it in the maybe pile, maybe it'll be counted, maybe it won't. And nationally, when you look at provisional balloting, as you might just expect as a matter of common sense, the percentage of people who actually go and follow through and vote provisionally and then prove up what they're supposed to is pretty low. It's disappointingly low, and for all the reasons you'd expect. If someone is a Mark Corin voter, let's say, and they show up, that result has been, the unofficial results have already been reported the next day. They're not probably going to bother to show up to their county auditor within a week. And I would bring up another point in terms of voter convenience and fairness. So for me, if I had to go back to the Hennepin County auditor or clerk within a week, no problem for me. Downtown Minneapolis, I live in Hennepin County, is on my way to work. It'd be kind of a pain to pay an outrageous fortune for downtown Minneapolis parking, and I'd grumble about that, but I could do it. If someone lives in St. Louis County and they're not in Duluth, you're probably taking most of the day off. If you live in Hibbing or Chisholm or Virginia, that's a pretty big drive to go sometime back within a week to your county auditor. So this is a big, big step. I just wanted to say that. Now, that's not to say we shouldn't have a discussion on it, and I applaud Senator Kiffmeyer for starting this discussion, but this is a big deal. This is the first time ever in state history when we'll be creating a maybe pile and doing provisional balloting. And at this point, unless I know more, I just have too many concerns to justify support. So thank you for your time and attention.
Thank you, Mr. Simon. Okay. Next testifier. Please state your name and your organization. And can all testifiers please make sure and sign in on the back? Or I think the list is on the testifier table on your left.
Okay, good afternoon, Senators. My name is Andy Seelick. I am the Executive Director of the Minnesota Voters Alliance. We're an election integrity group, and we've been working on election issues for approximately 10 to 12 years, somewhere in there. I lost track. But I want to just touch on a couple things. I thought I had a few minutes, but how are you talking 1 minute, Senator?
We have a total of 15 minutes, and
Okay.
now we're down to less than 12.
For everybody, so.
Please be
okay.
as accurate
Well,
as possible and detailed and brief.
I'd like to just touch on one thing Secretary Simon said. I think I disagree on the fact that I don't have any concerns for provisional ballots, and I think what the Secretary didn't say is that states very close to us, such as Iowa and Wisconsin, all have a form of provisional ballots and same-day registration. I think that should be noted. But one of the reasons why I wanted to testify, I think this Senate File 1225, I believe that it addresses a lot of problems in our election system. The court system goes through a rigorous process in issuing court orders specifically on vulnerable persons who are under guardianship. As many of you may know, up until 2012, there was no requirement in the state of Minnesota to assess a person's ability to understand the nature and effect of voting. The Minnesota Constitution clearly states that persons that are not entitled to vote are persons convicted of a felony, treason, insane, not mentally competent. It also mentions guardianship. Well, Judge Jay Quam, Hennepin County Chief Probate Judge, in 2012, ordered that because the Minnesota Constitution says not mentally competent and distinguishes that from under guardianship, which he said was unconstitutional, there's a Maine case that says that every person's entitled to due process, including a person under guardianship. So Judge Quam issued an order in Hennepin County. As we sit here today, there are guardianship proceedings going on. Every one of them assess a person's ability to understand the nature and effect of voting. So I want to mention one thing about what Judge Quam had said, because I think it's kind of important, and then I want to touch on the felon voting.
If you could make it as briefly as you can.
Okay. Judge Quam said it is one of the court's highest duties to ensure that the right to vote is protected for those entitled to vote. It is tempting to blithely pass over the question of whether a person subject to guardianship should be denied the right to vote. No pleasure comes from disenfranchising a person dealing with the challenges that create the need for guardianship. Given the court's role in overseeing it, the probate court is uniquely situated to analyze the question. In light of the fundamental nature and the right to vote, the court concludes that it has a duty to evaluate voting capacity of each ward at the time of the guardianship hearing. While this will certainly result in slight increased judicial time and cost, such administrative burdens are outweighed by the nature and the rights involved. So what we've had, it stemmed from a case up in Crow Wing County where an entire group home was taken down to vote. And about a half a dozen of those people had court orders restricting their voting right because they were mentally incapacitated. And that's one of the things now, as far as court orders go, is you have persons being determined to be incompetent, ruled by a court, and in the Secretary of State's election judge guide, on page 15, I believe it is, all he tells election judges to do is simply ask the person if they're mentally incompetent and if a court's declared that they're mentally incompetent. Ladies and gentlemen, that is absurd. And the reading of 201-155, let me just talk about 201-155 because that kind of
Mr.
summarizes.
Seelig, I'm sorry, we do have to limit you to that statement. We do appreciate, or to that point, we do appreciate all of the information that you've provided, but we do have a very tight time frame, and we do have a variety of other
Okay,
testifiers.
thank you very much.
Thank you, Mr. Seelig. Next testifier, please.
Good afternoon, Chairman Kiffmeyer and committee members. My name is Pamela Hoops. I'm the legal director of Mid-Minnesota Legal Aid's Minnesota Disability Law Center, which is a statewide program of Mid-Minnesota Legal Aid and designated as the protection and advocacy system for Minnesota. The Disability Law Center provides free legal assistance to people with all types of disabilities, and including providing nonpartisan voter education and rights information to people with disabilities and their families. Because many people with disabilities face barriers to voting, voters with disabilities vote at a lower rate than other eligible voters. And although Minnesota-specific statistics on voting rates of people with disabilities are not available, a national 2013 Rutgers University study on disability voter turnout and barriers to voting found that eligible voters with disabilities voted at rates ranging from 8 to 12% percentage points lower than voters without disabilities. And our experience with voters with disabilities in Minnesota confirms that Minnesotans with disabilities continue to experience barriers to voting and resistance to their full inclusion in the electoral process. Those barriers include physical accessibility issues to enter the polls, lack of transportation to the polls, especially in greater Minnesota, sometimes malfunctioning ballot marking machines, and attitudinal barriers. As recently as 2012, defensive litigation in federal court was required in Minnesota to preserve the voting rights of people under guardianship. And that challenge was based on outdated prejudice that people with disabilities are not competent to vote. This bill's provisional ballot requirement in order to overcome a challenge, we believe will create an additional barrier to voting. People under guardianship who a court has found not eligible to vote are correctly voted on the voting roster in many instances. But sometimes the roster is not up to date, so the voter might be challenged even if they are actually eligible to vote. Under the current system, the voter can self-certify their eligibility at the polling place and proceed to vote. Given the absence of documented voter fraud for this group of voters, this current system of safeguards provides a wise balance of protecting voting rights while preserving the integrity of the voting process. But the proposed provisional ballot process will create an unduly high risk of disenfranchisement for voters with disabilities, as it requires them to again appear to prove their eligibility and face likely barriers such as lack of transportation, physical access, communication barriers, need for physical assistance a second time, all within a very tight time frame in order to have their vote counted. Finally, the provisional ballot will also, we believe, have a chilling effect on voters with disabilities turnout, including voters who are not under guardianship. In our very extensive trainings of voters around the state and information sessions, many voters with visible disabilities, including many people who are not under guardianships, express great fear of going to the polls to vote and being improperly challenged based on another person's unfounded belief that they should not be voting because they appear to be too disabled, in quotation marks, to vote. Of course, this is a judgment based on illegal bias, and only a court can make that determination. Under current law, faced with this type of challenge, voters can still assert their eligibility by self-certifying under oath and vote. But under this bill, if a challenger fills out a challenge form, the voter would then be required to undertake the strenuous...
Excuse me, Mrs. Hopes, would you be able to, we do have a few other testifiers.
Yes.
Would you be able to wrap this up within 30 seconds,
Absolutely. They would still
please?
have to go through that provisional ballot process, even if the challenge is specious in nature. So for those reasons, we are concerned that this will intimidate more voters with disabilities from attempting to exercise their right to vote. So thank you for considering these points.
Thank you, Ms. Oak. We appreciate your testimony. Next testifier, please. Please state your name and your organization you're with.
Okay, my name is Kathy Tomsich, and I'm a member of the League of Women Voters, and I've been a head election judge for over 12 years in Ramsey County. I would like to ask a question first for clarification. I read the bill prior to the amendments that were offered, and I wanted a clarification on that amendment.
Senator Kiffmeyer?
Mr.
do you have a
Chair,
specific
I did
question?
go
Mrs.
through the amendment as part of my presentation. Do you have a specific question? But I would
Ms.
rather they
Ms.
use their
Tomsich.
time for testimony.
If you could just provide, if you could provide your testimony, we do have a very limited time frame, and there's still 2 additional
Okay.
speakers, I believe, behind you.
I will be testifying in opposition to 1225. First of all, we oppose the introduction of provisional ballots in Minnesota. It's an unnecessary and expensive change to our election system, an unfunded mandate that will only make our elections more complicated for the voters and election administrators without improving the integrity of our elections. Our current regulations regarding challenged voters are reasonable, clear, efficiently administered, and fair to the voter. Any challenged voter who answers questions under oath and who answers indicate that the individual is not eligible to vote in the precinct should not be allowed to vote. Allowing that voter to cast a provisional ballot certainly does not improve the integrity of the system. At the same time, the counties would be burdened with the cost of administering the provisional ballots. Our election system with election day registration and the process used to handle challenged voters has been designed to maximize access to the ballot box while maintaining election integrity. In general, provisional ballots make it more difficult for a voter to have their ballot counted since the voter is required to take at least one extra trip to a city or county election office. This voter may have to take time off from work or seek help with transportation. It especially affects the disabled or the low-income population. Introducing provisional ballots will not improve access to the ballot box. It's the exact opposite. It will make it more difficult for those populations to cast their ballot and have it counted. Secondly, Senate File 1225.
Excuse me, Ms. Tomsich, would you be able to wrap it up quickly? We do have 2 additional speakers that we'd like to get in,
Okay.
and prior to our time elapsing.
I would like to.
Thank you.
We object to the public information list data that is, Senate File 1225 would include in the public information list data that is now not public, and we object to that. This data, the Office of the Secretary of State testified in this committee on February 21st that this data is only current as the date the office receives it. And sometimes, unfortunately, the information is not accurate. This bill would allow the data to be public, which could have negative consequences for the voter. And our present system allows the voter to correct the status at the polling site and in an uncomplicated manner without the voter being worried about his or her status being
Ms.
made
Tomsich?
public or concerned
Sorry, but
about inaccurate
we've run out of,
information.
we appreciate your testimony, we've run out of time, but we do have 2 different additional speakers that we need to get in.
Mr. Chair,
Senator Kiffmeyer?
I think it's good for the testifiers to know that they can submit, if they have written comments, they can just submit them and it'll be distributed to the committee. So that would be able to have a more full testimony if they would
Thank you,
like.
Senator Kiffmeyer. Mr., we do have additional testifier. Mr. Hazy, could you please state your name and organization?
Yes, good afternoon, Mr. Chair, members of the committee. My name is Mark Hazy, and I'm speaking on behalf of the ACLU of Minnesota. Others have spoken about the potential logistical challenges with this bill. The ACLU is also in opposition to Senate File 1225. So I will just try to keep it to some core principles at stake here. It's the position of the ACLU of Minnesota that the right to vote is a core principle of our form of democratic government, perhaps the core principle. If you do not have a choice in who your government is, we all know that that government can erode or even take away some of the other core principles that we all hold dear. as you already heard from Secretary Simon, the state of Minnesota has also erred on the side of making sure that more people are able to vote, that we make the franchise as expansive as possible under law, rather than erring on the side of keeping people from voting. And we're concerned that this bill may keep more people from voting. Minnesota has one of the best turnout records in the country. We'd like to see it that way, and based on the testimony you've already heard, this bill may harm that reputation and that record of excellent voter turnout. And just one other note along those lines, the history here in Minnesota, I mean, based on our research, and this is similar to what Secretary Simon said, it was 1881 when the law that allows somebody to take an oath that they're eligible to vote at the polling place was enacted. And just a reminder also on that law, if somebody illegally votes after taking that oath, that is a felony crime, and it's a very serious consequence, and I don't think people take that lightly.
Thank you for your testimony, Ms. Knight. Unfortunately, we've exceeded our 15-minute allotted time frame. Senator Kiffmeyer, do you?
Well, Mr. Chair, I would just like to have this testifier just have at least 1 minute to introduce himself and make some comments.
In lieu of the time frame, Senator Kiffmeyer will allow for one additional testifier. Unfortunately, if anybody else here had testimony, please submit that in written form. It's still available. Please state your name and organization which you're with.
My name is Don Baumgartner. I'm an election judge, Minnesota election judge. I've been an election judge since 2012. As an election judge, it is my duty to uphold election law pursuant to the Minnesota Constitution. Every Minnesotan wants fair and honest elections with clear statutes that will instill confidence in the process, and all eligible voters can cast a ballot and ineligible voters cannot. Under current statute and policy, we are enabling illegal voting. Current statute has been interpreted to allow individuals who are marked challenged on the poll roster to cast a ballot if they swear they are eligible to vote. My duties as an election judge are to uphold my oath and diligently prevent voter fraud. This conflict created by self-certification by those who may or may not be eligible to vote would be prevented by SF 1225. Under the proposed bill, a person who is designated as challenged ineligible to vote and who claims to be eligible would have the opportunity to cast a provisional ballot and have their vote counted if they are eligible. SF 1225 will be of great assistance to election judges throughout Minnesota.
Thank you, Mr. Baumgartner, for your testimony. That concludes our testimony section. If you, ma'am, I understand you may have some additional testimony. You can submit that in.
I'm Carol Johnson with the Citizens for Election Integrity, and I'll leave my comments on in opposition to the bill.
Thank you. Discussion? Senator Newman?
Mr. Chair, Senator Kiffmeyer, my comments are going to be very, very brief. We've heard a number of testifiers come forward and espouse as to the fact that there are no problems with our election system, and talk in terms of the great turnout that the state of Minnesota has. And for me, what is being lost in the conversation is the fact that we also have to balance that with voter integrity. So I think that this particular bill, and in particular the provisional balloting idea, is a good one, because I do believe that there are times when people vote and they should not be voting, they're not eligible. Provisional balloting, though it may be the first time that we are entertaining it in the state of Minnesota, that of and of itself does not disqualify us from considering moving in that direction. So for those reasons, Mr. Chairman, I do support Senate File 225. Thank you.
Senator Rest?
Thank you, Mr. Chairman. I think this bill, as well as several others that are on the list, are solutions in search of problems, and I oppose them all.
No further discussion? Senate file, or I'm sorry, Senator Kiffmeyer, would you like to have
Yes.
your final comments?
Just briefly, Mr. Chairman, I appreciate everybody who's come forward, but I will restate again, this process enables those who are entitled to a vote to have a vote, but it also honors our Constitution. Those not eligible shall not be permitted to, and yet we still give them through provisional ballots, as other states with same-day voter registration have done, so Minnesota can do in an excellent way as well. And with that, Mr. Chairman, I would just ask that in this particular case, this bill be laid over for
Thank you,
possible.
Senator Kiffmeyer. Senate File 1225 will be laid over for possible inclusion in the election omnibus bill. Thank you.
Okay, we will now go on to the next bill on the agenda, Senate File 581. And Senator Corn, you are presenting this bill.
Thank you, Madam Chair. You are correct. Senate File 581 is another ballot issue or initiative. And this ballot or this initiative is relating to campaign finance, prohibiting use of public funds to promote or defeat a ballot question, proposing coding for new law statute, Chapter 5, 10A. What this is the common sense bill. What it does is it targets and limits the ability to or restricts the ability of public officials from advocating for or against any ballot issue, particularly the Secretary of State position and/or any and/or all other public officials. Those means to move activities or options forward within our election process exist, and once those opportunities reach the ballot, it is really up to the citizens and those outside of our public officials to move those ballot initiatives one way or another. It is not the role to utilize public resources to participate in those activities. And that's it. It's no more complicated than that. But it's about integrity in our election process and our elected officials as well as government officials.
Senator Rest.
Madam Chair, are you going to be taking a vote on this bill?
Madam Chair, I'm sorry. Senator Rest, give me just one moment. So is that your presentation, Senator
That is
Corn? I just
correct.
wanted to be sure you weren't just taking a breath.
Nope,
Okay.
that is correct.
Senator Rest.
Madam Chair, is it your intention to take a committee vote on this bill?
Yes, it is.
Request a roll call.
Thank you. I'm not calling for the vote just yet. Just want to make sure any testifiers in the room today in regards to this bill? Okay, members? Oh, with that, okay, we'll proceed to, Senator Carlson.
Thank you, Madam Chair. Is it only public funds that are expended and appropriate for public agencies, like, for instance, Secretary of State? But does it also include any groups that have tax-exempt status, for instance? A tax-exempt organization that may do some lobbying or may produce something that is for or against a ballot initiative?
Senator Corn.
Madam Chair, Senator Carlson, the intent of the law is for elected officials as well as public officials, so those employees of a government entity.
So, Senator Carlson, from that, it would be, that would not include nonprofit in regards to this. This is public dollars. Senator Carlson.
And thank you, Madam Chair. So just to be very clear, this means charitable nonprofits as well, those that are exempt from paying taxes and those that where a contribution to that organization is tax exempt.
Those would not be considered
Senator
public
Corn.
officials. Sorry, Madam Chair, thank you. Those would not be considered public officials.
And Madam Chair, just to be clear, that there are public dollars that are forgiven for tax-exempt charitable organizations.
Senator Corn.
Madam Chair, Mr. Carlson, or Senator Carlson, yeah, the intent is for public employees, the resources in their positions, to not participate in or advocating for or against a bill or a ballot initiative.
Senator Rest.
Thank you, Madam Chair. You know, in the past, I know secretaries of state have been criticized for exercising their First Amendment rights, but I think, once again, this is a solution in search of a problem, and I don't know of any Secretary of State, including yourself, Madam Chair, who was ever accused of using public funds on a ballot initiative or brought into a court of law with regard to that kind of charge. I don't think this is another bill that's not necessary. It's a solution for which there's no problem.
Senator Rest, I just want to clarify, this is for the use of public dollars. It does not infringe on an individual right using their own dollars. This is when they're using public dollars. Senator Corn?
Thank you, Madam Chair. And you're correct in their position to influence as an elected official and or public employee.
Thank you. Senator Kent?
Thank you, Madam Chair. And Senator Corn, to Senator Rest's point, can you point to any examples of when the Secretary of State or other public officials have expended public funds?
I believe there.
Just a moment. Senator Corn.
Madam Chair, Senator Kent, I believe in 2012 there were a variety of issues with the Secretary of State had flown throughout the state, promoting and or speaking against ballot initiatives.
But Madam Chair, as a
Senator
follow-up,
Kent?
but were there there were no public funds expended in that case? That was my question. Were there public, can you point to an example when public funds were expended?
Madam Chair.
Senator Corn.
Senator Kent, it was a public official traveling the state on the state dime, dollar, and resources as an official capacity to promote or to advocate against the ballot initiative.
Senator Newman.
I'd just like to add a little bit to Senator Kent's question and Senator Rest's question. The ballot initiative that Senator Corn is referencing did in fact happen in 2012, and I was aware of the fact that then Senator of State or Secretary of State Ritchie did go around the state using state transportation and was involved in meeting with local officials, and then would conclude the meeting by taking a position on the constitutional ballots that were on the ballot in the upcoming general election. I'm also aware of the fact that the Department of Human Rights Commissioner did the same thing. I absolutely agree with Senator Corn, and I thank him for bringing this bill forward, simply because I think it's totally inappropriate for the Secretary of State to use his or her position to try and influence the outcome of a constitutional ballot initiative using state funds to do that. Now, if the Secretary of State wants to make a personal statement, they have as much right as anybody else to do that. But to use the Secretary of State's office and the public money to influence the outcome of a ballot initiative, in my estimation, is wrong. The language involving no public official, I believe, is in this bill because a commissioner of a state agency is a public official, at least in my mind, and ought not to be using that position to try and influence the outcome of a ballot initiative. There is a line that can be crossed by public officials and the Secretary of State in that regard. And so, you know, I'm sorry that there are some who feel that this has never happened, but that isn't true. And perhaps there are some that feel it's okay to use public funds to influence the outcome of a ballot initiative. I happen to believe that it is improper. And I truly think that this is a fairly straightforward bill, and I just don't understand the opposition as to how we would justify allowing a state official, a public official, and an elected official to do what this bill is preventing. And in completion, I will tell you that back when this occurred, I asked the legislative auditor to take a look at the law underlying this particular question. And I found it, and oddly so, that there was no statute that covered or prohibited this activity. So, Senator Corrin, I appreciate the fact that you're coming forward with this bill. I think it's absolutely appropriate, and I think that we as the legislature should prohibit the Secretary of State in the future or any other public official from using public money to influence voters when it comes to ballot initiatives. Thank you, Madam Chair.
Thank you, Senator Newman. Next on the list, actually, we have Senator Lane.
Thank you, Madam Chair. I do recall that time, and I never in that time heard the Secretary of State actually take a stand on the issue. I will be clear about that. I did hear him explain the issue, and he very clearly said, I am not taking a stand. That's for other people to take a stand. I am merely clarifying the issue, which was very confusing to people. And also, beside that, we actually had a commission to look at how the idea of, instead of requiring voters to bring in photo ID, how we could have the state be responsible for having a photo ID available, which would work very nicely with electronic rosters, by the way. And that is what we did also. But it's just a part of the deal of how do we make this work? The idea of one was not going to work, the idea of the other would work, but every single time the Secretary of State actually spoke on this issue, and I did hear him, he made it clear, I am not taking a stand. I am merely clarifying what is brought before the voters.
Thank you, Senator Lane, although I know not any one of us was probably at every event, but for our personal knowledge, we are speaking to. Senator Nelson.
Thank you, Madam Chair. Well, I recall the issue as well, but I wanted to just bring some specific facts to the case and some quotes so that I think it's important for people to know that. I have a news story here from Minnesota Public Radio on July 3rd, 2012. Certainly, you can find the story yourself, but let me just say, the story states that Ritchie has been speaking publicly and often critically about how a requirement for voters to show photo ID at the polls would change the state's current election system. And then it goes on, and there are some more quotes from Mr. Ritchie. I think the fact this is being proposed for the Constitution, so it can never be changed by the legislature or by the Minnesota Supreme Court, is a big deal, he said. This is not like legislation. This is forever. He went on to say it's a huge amount of, these are in quotes, huge amount of money at a time where every single budget, except for a few special items, are being completely squeezed. I mean, cut, 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 Ritchie said. So let me just say, members, it is very clear that the former Secretary of State did travel around the state, and he did specifically advocate against a particular proposal, and the proposal in and of itself is not really the issue right now. The issue before us right now is why is this law needed, to answer Senator Rest's question. I believe it is a direct response to the abuse of power that we saw in 2012. And I would encourage members and the public to look for themselves at the exact quotes that the Secretary of State said. However, he did go on to say after all of those quotes, we're not here to tell voters, we're not here to tell the Supreme Court, we're not here to tell people how they should be thinking about this. So if he can justify all of those comments and then say, oh, but we're not telling people how to vote. So I would just encourage members to go to the original source yourself. You can check out the NPR news story from July 3rd, 2012. So just because you're saying you're not doing something that you just previously said or did does not mean it didn't happen.
Thank you, Senator Nelson. Senator Rest?
Thank you, Madam Chair.
And then Senator Carlson, and then Senator Newman.
The response when someone is going around and presenting both the pros and cons of an argument on an important question, it is not, doesn't fall on them for the responsibility of what the press reports. And if the press reported when someone like Secretary Ritchie is saying, here are the con arguments, and lists all those, and then says, and here are the pro arguments, and the reporter only presents the con arguments, I don't think, and then the Secretary ended up with saying, but you can make up your own minds. In some states, the Secretary of State or some other public official is required to put forth booklets on ballot initiatives, we don't have them here in Minnesota, but initiative and referendum. They're required to get from the proponents of a particular ballot initiative what the arguments are for, and then what the arguments are against, and they're required to spend public money to do that. We don't have that kind of requirement in Minnesota. We've tried in the past to do that kind of election guide, and it's been shot down. But simply because a reporter chooses to only put in their article that the con arguments, I don't think is an indictment of Secretary Ritchie. And as a matter of fact, I commend him for what he did in making sure that people knew the costs, whatever list of benefits, if clearly people in Minnesota didn't think there were enough to cause them to approve that measure, but it seems to me that he did yeoman service to our voters, and I, for one, am grateful for it and wouldn't for a second condemn him for doing so.
Senator Carlson.
Thank you, Madam Chair. And Senator Corn, I think what we're discussing here, it seems to me, is confusing to me, because you said that there's a freedom of speech issue on the part of the official. So whatever the official said is a freedom of speech issue, even if it's promoting an issue. And what you're trying to get at, I think, is the expenditure of public funds. So is there public funds that were expended in any of these instances that we're talking about, and what public funds were those?
Madam Chair?
Senator Corn.
Senator Carlson? It's clearly it was on official capacity, official duty, which is a consumption of state resources. And so, yes, those are state dollars and travel and expense to travel throughout the state and express those views. And as clearly by the NPR articles and all the other information provided, it's how you present the information. We always will work diligently to protect the freedom of speech, but at the same time.
Thank you, Senator Newman. Senator Carlson, we have limited time,
But I need to get this cleared up here. So that means that you're talking about the travel expenses that were public expenses, and we're all here with some public dollars. We're getting mileage, we're getting per diem, we're getting paid. So that means that none of us that are in the Senate or the House can say anything when we're in session, because those are public dollars that get us here. Those are public dollars that fund some of our housing, some of our mileage, and certainly our per diem. So we're expending public funds. That means that we need to be gagged at the same time. Isn't that how you read it?
Senator Corn, we have two others on the list, and Senator Carlson, we will defer that to Senator Newman is next.
Madam Chair, I simply wanted to add that beginning on line 1.11, there is language that allows the Secretary of State to provide impartial and balanced information on ballot questions. And if the Secretary of State stays within those guidelines, everything should be just fine. But again, I believe it's very improper for the Secretary of State to spend public funds, including time when he is on his salary, being paid by the people of the state of Minnesota, as a Secretary of State, promoting the ballot initiative after it has cleared the legislature now. That's what we're talking about. And I think in terms of Senator Carlson's observations, we are in the legislature. It is our job to talk about these issues and to take a position pro and con. That's what we're here for. It is not what the Secretary of State's job is for. So I would respectfully disagree with Senator Carlson in that regard. Thank you, Madam Chair.
Thank you, Senator Newman. Senator Nelson?
Thank you, Madam Chair. Just to clarify, my comments or even this whole discussion is really, in my mind, we're talking about Senate File 581, and should public funds be prohibited for ballot advocacy by the Secretary of State. And so this is, my comments about previous news articles were only meant to show that this has been a problem. I believe the comment was made at the table here that this was a solution in search of a problem. And the point is, there has been a problem. And hopefully, Senate File 581 will help make clear that state resources should not be spent, public funds should not be spent by the Secretary of State for reasons of advocating for ballot initiatives. And I would think that I would be surprised if there was objection to that, but that's what I understand the intent of 581 is to simply not litigate what happened in the past before this law was in place, but if 581 passes and is signed into law, then it would be very clear that the Secretary of State should not use public funds to advocate for a ballot initiative, which seems certainly very logical, yet protects free speech. Certainly one could do that on their own dime, but it's using the state resources to do so.
Thank you, Senator Nelson. Senator Kent, the last.
Thank you, Madam Chair. And I think Senator Nelson sort of brings up exactly the point that we're concerned about. On lines 1.11 and 1.12, the Secretary of State may spend public funds to provide impartial and balanced information on balanced questions that does not have the effect of promoting or defeating a ballot question. And I believe that the bill that is before us muddies the issue. We have just looked at a case where the argument can be made that it was in the course of doing the Secretary of State's job that he was providing balanced information, and that there were interpretations made that by some, subjectively, that was advocating on one side of that issue. I think this opens up an entire can of worms that is very problematic, and I think Senator Carlson's point that right now, if you look in Section 2, or Paragraph A of Section 2, and what it says to us and our ability to advocate for public ballot initiatives, I think this is a real problem. I think there's a lot of work that needs to be done on a bill like this. I think there are legitimate questions to be discussed here, but I think this is a big problem.
Well, regarding this, I will note that this has to do with the prohibition only applies after final enactment of a legislative act that places, and this is the one, a ballot question on the ballot. So it's exclusive to that. Just like to mention that if you only present pros or you only present cons, no matter what you state at the end, whether you use your own money or private money, I think it is very important. And just to mention that currently the Secretary of State does have the authority to give biased information to the general public via the website. In other words, those proponents or opponents are able to submit that, and without filter, without criteria, able to have those listed in such a way, and that is currently, by law, the ability of the Secretary of State to do so. But this is a different context. So, Senator Corn, I'll give you the opportunity to make a closing statement, then we'll proceed to a vote.
Thank you, Madam Chair. I believe, and I think that you just covered on the last key component is really that the prohibition and applies after the legislative has created the ballot initiative, and that appears to be the defining moment, and I'll leave it at that. Thank you.
Thank you, Senator Corn. We'll proceed to a vote. Would the clerk report the roll?
Senator Kiffmeyer?
Aye.
Coran?
Aye.
Carlson?
No.
Jazinski?
Aye.
Kent?
No.
Lane? No. Nelson?
Yes.
Newman?
Yes.
Rest?
Oh, no, sorry.
Westrom is absent.
Okay, the results are there being 5 ayes and 4 nays. The motion passes and is adopted, and will go to the general orders. Thank you. Thank you, Senator Corn.
Isn't there a fiscal note for it? I didn't even ask that.
Next bill on the agenda, Senator Lane, Senate File 323. Senator Lane.
Thank you, Madam Chair. I hope this is a little bit lighter. Right now, a person who applies for a driver's license or a change of address or an identification card will be asked if they want to register to vote at the same time. The information in the application is then sent to the Secretary of State to be added to the voter rolls after checking to make sure they're eligible. This bill simply adds onto the application form a box for the applicant to check in order to decline to be registered to vote. If that box is not checked, the information is sent to the Secretary of State just as now. So it would be moving from an opt-in to an opt-out. This bill adds instruction permits into the process and requires the Secretary of State to determine if the individual is 18 years of age or older. If not, the Secretary of State waits until the application has turned 18 in order to determine whether they're eligible to vote. The Secretary of State receives from the Department of Public Safety the voter's name, address, date of birth, citizenship, driver's license number, county, and city. Then that information is used to determine if the applicant is already registered, if the information needs updating, or if the individual is not eligible to vote. And then any new registration information is sent to the county auditor where the voter lives, and the auditor mails the voter the usual notice of registration. So it's really just changing from an opt-out to an opt-in to an opt-out.
Thank you, Senator Lane. Then we have testifiers.
Madam Chair,
Senator Rest?
could I just ask that same question again? Is it your intent to lay this bill over or to take a vote?
To lay it over.
Thank you.
Mm-hmm. Secretary of State Steve Simon, please welcome.
Well, thank you, members, and thank you, Senator Lane, Secretary of State Steve Simon. Thank you, Madam Chair. I appreciate it. I'll be quick, as I know you have a lot more to do. I think this bill has the potential to make a great system in Minnesota even better. So why are we great? One of the reasons we're great is we have had a bipartisan consensus over the years in terms of voter-friendly. That is to say, we prioritize voter convenience above most other things, and I think that has served us well. We've gotten to a point where routinely Minnesota has been #1 in the country or at the very top of the list in elections. In fact, for 9 elections in a row, Minnesota was #1 in the country until recently. We started to fall off the last couple of years or so, and in 2014 we fell to #6 in the country. Still good if you're grading on a curve, 6 out of 50, not bad, but not quite up to our usual high Minnesota standards. So our big rallying cry as a state this last year was to get us back to #1, and we did that. So now we're back on top of the list, which I think is a good thing. Several states, 6 plus the District of Columbia, already have something like this, automatic voter registration or an opt-out. And there are more and more that are seeking to adopt it. And I think, as Senator Lane said, in some ways there's less here than meets the eye, in the sense that we already have an opt-in system. All this would do is change the presumption. Instead of checking a box if you do want to be registered, you would check a box if you don't want to be registered. Voters like it because it makes registering hassle-free. It decreases wait times at the polling place, and in other states, at least that's been the experience. Administrators like it because they have fewer same-day registrations to process. And it's good for voter integrity and accuracy because it gets more people in the system earlier. And I really want to dwell for a second on that point. I hope that's something we can all agree upon, though we have same-day registration in the system, and I wouldn't want to see us mess with that personally. The fact is, the more we can get people registering before Election Day, and even well before Election Day, the better. Then we can do the filtering and the screening and the checking that so many of us, all of us really care about in terms of voter integrity. And of course, political parties, if that's even a consideration, love this as well because it gets more people in the system earlier as well. So campaigns and elections can function more smoothly. So this is an idea, I think, whose time has come nationally, and I thank Senator Lane for starting the discussion on this issue. Thank you.
Secretary Simon, I have just one quick question for you. In this bill, there's information that comes from the Department of Public Safety. Is this data that you currently receive and that you use in the state voter registration system? Secretary Simon,
yes, Madam
sorry.
Chair, yes. We do receive routine data from the Department of Public Safety. That's right.
And Secretary Simon, you have confidence in this data that comes from them as accurate?
Yes. Yes, I do, in
Okay.
general, yes.
Thank you, Secretary Simon. All right, we have another testifier. Two of them. Why don't you come on up, and if you're right there.
Good afternoon. I'm Betty Ruther, a volunteer lobbyist for the League of Women Voters of Minnesota. League of Women Voters Minnesota is a nonpartisan citizen organization. We do not support or oppose candidates or political parties. We do, however, advocate on issues and legislation that further our commitment to voting rights for all citizens. I have also served as an election judge for several years in the city of New Brighton. I will testify in support of Senate File 323. This bill allows for an automatic voter registration at the time of application for a driver's license, instructional permit, or state ID card, age and citizenship permitting, of course. This will create a statewide voter registration system more accurate and more up-to-date than anything we currently have, and will add integrity to our election system. Perhaps more importantly, Senate File 323 will allow for another way to capture the civic engagement of our young people and put them on the path to becoming informed and involved citizens. We know that voting patterns are formed by early participation that continues throughout adulthood. If we want an engaged electorate, we need to ease their registration at the same time that we improve the accuracy of our voting registration system. There are also benefits at the local level. It will ease Election Day registration, resulting in less congestion at the registration tables on Election Day, and freeing up space in often cramped polling sites. Cities that provide extra registration personnel 3 weeks prior to Election Day might be able to cut back on this service and save money. The League of Women Voters asks members to support Senate File 323.
Thank you very much for your testimony. To our next testifier, please state your name and title if you have it.
Sure. Madam Chair, members of the committee, my name is Renal Ray. I represent the Minnesota Council of Nonprofits. MCN is a statewide association of over 2,100 nonprofit organizations with offices in 7 regional centers that include Duluth, Moorhead, Bemidji, St. Cloud, Mankato, Rochester, and the Twin Cities. MCN supports improvements to structures and systems of democracy to expand access to voting for all eligible Minnesotans and reducing barriers to participation in voting. MCN supports the efforts to bring automatic voter registration to Minnesota through thoughtfully crafted policy. The Minnesota Council of Nonprofits has an interest in the success of this issue. For many years, we and many of our members have been providers of voter registration in Minnesota. It is a natural role for nonpartisan nonprofits who are directly connected to people who are often disenfranchised from voting. Every election cycle, we develop materials, provide training, host voter registration events, and provide voter registration materials to our members. Minnesota nonprofits work hard to reach community members that are often not reached. This includes our elders, our youth, people in greater Minnesota, those with disabilities, those that are homeless, new Americans, and those that are remotely located or isolated, either in greater Minnesota or in our urban centers. We recognize that the nonprofit sector's role in voter registration is one of filling gaps, providing a service which could and should be provided by government. Automatic voter registration improves government service to citizens and relieves nonprofits of this duty so we can focus on nonpartisan voter education and mobilization efforts. We believe automatic voter registration is a win for the people, governments, and nonprofits of Minnesota. Thank you.
Thank you very much, Ms. Ray. Appreciate that. Senator Lane, a closing comment? Well, first, I'm sorry, members. Any questions? Senator Carlson?
Mine's more of a statement that I think it's
Briefly
really.
then, Senator Carlson.
Pardon me?
Just briefly then.
Sure. It's, to make our voting records more accurate, I think this is really important. I personally have seen some voter records that have had, for instance, a person that was a foreign speaker at one time would cross their 7 and it would wind up being a 4 in the voter file, and people that have transposed numbers would wind up being an error in the voter file. And having the same address as your driver's license, I think, is another screen to make the records really accurate. And I think seeing this kind of increase in our voter accuracy means that we're going to have better voter integrity. So I fully support this.
Thank you, Senator Carlson. Senator Lane?
I will just say that, yes, it gives us an opportunity to verify the information before they even get to the polls.
Thank you, Senator Lane. This bill will be laid over for possible inclusion.
Next on the agenda is Senate File 86. Senator Kiffmeyer.
Thank you very much, Mr. Chairman and members. I'm very pleased to present Senate File 86 to the committee today. Just to initiate the conversation about this, I would like to start by reading from the Constitution of the State of Minnesota, which has such an Article 4, which is the legislative department. In Section 3, it reads, Census enumeration, apportionment, congressional, legislative district boundaries, Senate districts. At its first session, after each enumeration of the inhabitants of this state made by the authority of the United States, the legislature shall have the power to prescribe the bounds of congressional and legislative districts. Senators shall be chosen by single districts of convenient contiguous territory. No representative district shall be divided in the formation of a Senate district. The Senate district shall be numbered in a regular series. So the specific portion of this Constitution states that it is the legislature that shall have the power to prescribe the bounds of congressional and legislative districts. And so, Mr. Chair and members, the Minnesota House and Senate draw legislative and congressional maps in the current process. The governor signs or vetoes. If no plan is signed into law, the court draws the maps. What this bill does is it verifies that the Minnesota House and Senate draw legislative and congressional maps, that the governor signs or vetoes, and if no plan is signed into law, the court draws the maps. Typically, the House and Senate adopt redistricting principles. However, there is no guarantee of that since it is not in current statute. So this is often left up to every 10 years, a vote, and those principles are established. By placing this in statute, no matter which body, no matter which court does, Minnesota law would prevail as far as redistricting principles. But again, these principles have been used previously, and Minnesota has done very well. The bill puts redistricting principles into law and ensures then consistency in the process. And these principles protect against gerrymandering, packing, dilution, and other things as well. So the big thing is to remember that it is the responsibility, the constitutional responsibility of the legislature to do the redistricting. Matter of fact, the legislature is an elected body that can be held accountable for its actions. A commission cannot be voted out of office and is not directly accountable to citizens. The people choose their legislature every election year. They cannot choose a commission. The legislature knows the state better than any other body because they are represented in the entire state. All 67 Senate districts represent one by one the entire state, as do House members. Minnesota's system is different than the rest of the nation. William Mitchell Law Review says Minnesota should adopt standards, principles, and that is what this bill does, as many other states do. And just to mention that no matter the thought that somehow by establishing a commission you avoid gerrymandering, that is not the case. Matter of fact, in the state of California, there was a case where they had a commission that was dealing with gerrymandering and with other things. So it is not a matter that just because you have a commission that cannot happen. But most importantly, we're required by the Constitution to the legislature to do redistricting, and this bill in particular upholds the Constitution by stating that that will be done by the legislature, consistent with the requirements of the Minnesota Constitution. And so by upholding the Constitution and the laws of the state of Minnesota, by putting these redistricting principles into law, and because for the sake of those who may not have a copy of the law, who may just be watching today, I think these are very important because they pertain to every single person in the state of Minnesota, that I read what these principles are. A representative district may not be divided in the formation of a Senate district. What's important here is that in Minnesota we have one Senate district. There is an A side and a B side, but the Senate district itself in its entirety has two House sides and not allowed to break that up and take a piece of one Senate district and put it in another part. This is called nesting. Equal population. Another principle. Legislative districts must be substantially equal in population. The population of a legislative district must not deviate from the ideal by more than 0.5, 0.5% plus or minus. Congressional districts must be as nearly equal in population as practicable. The federal law governs in this regard, and it is a very strict apportionment. The next section talks about contiguity and compactness. Another principle, the districts must be composed of convenient, contiguous territory. To the extent consistent with the other principles in this section, districts should be compact. Contiguity by water is sufficient if the water is not a serious obstacle to travel within the district. Point contiguity is not sufficient. In many cases where you have gerrymandering, that having a single point of contiguity, meaning they just touch at that single point, often gerrymandering comes from that. And if you have a statute that does not allow that, that is a big point in helping to not have gerrymandering. This also requires a numbering legislative districts numbered in a regular series, and it describes 1A in the northwest corner. Some people wonder, why is this northwest corner of the state always get number one. Well, that is a common language that is included in the redistricting. So it starts at 1A in the northwest corner of the state and proceeding across the state from west to east, north to south, but bypassing the 11-county metropolitan area until the southeast corner has been reached, then to the 11-county metropolitan area outside the cities of Minneapolis and St. Paul, and then on into Minneapolis and St. Paul. Congressional district numbers must begin with District 1 in the southeast corner, the opposite, of the state, and end with District 8 in the northeast corner of the state. So many of us have kind of sometimes wondered, how do you go through all those numbers? There it is right there. Minority representation is another principle. The dilution of racial or ethnic minority voting strength is contrary to the laws of the United States and the state of Minnesota. Dilution, these principles must be construed to supersede any provision of the Voting Rights Act of 1965 as amended. A redistricting plan must not have the intent or effect of dispersing or concentrating minority population in a manner that prevents minority communities from electing the candidates of their choice. They must have a chance in the election process. Minor civil divisions. A county, city, or town must not be unduly divided unless required to meet equal population requirements or to form districts composed of convenient, contiguous territory. Another principle that is in direct opposition to gerrymandering. A county, city, or town is not unduly divided in the formation of a legislative or congressional district if the division occurs because a portion of a city or town is non-contiguous with another portion of the same city or town. And this is keeping those communities of interest as a city or a town together. Despite the division, the known population of any affected county, city, or town remains wholly located within a single district. Preserving communities of interest is another principle. Districts should attempt to preserve identifiable communities of interest where that can be done in compliance with the principles under this section. For purposes of this subdivision, communities of interest means recognizable areas with similarities of interest, including but not limited to racial, ethnic, geographic, social, or cultural interests. Next one is on data to be used. The geographic areas and population counts used in maps, tables, and legal descriptions of the districts must be those used by the Geographic Information Systems Office of the Legislative Coordinating Commission. The population count shall be the block population counts provided to the state under Public Law 94-171 after each decennial census, subject to correction of any errors acknowledged by the United States Census Bureau. Just a comment, we are under federal law in this regard as well. It's a national decennial census process. Nothing in this subdivision prohibits the use of additional data as determined by the legislature. Next one, consideration of plans. A redistricting plan must not be considered for adoption by the Senate or House until a block equivalency file showing the district to which each census block has been assigned in a form prescribed by the Director of the Geographic Information Systems Office has been filed with the Director. Priority of principles. Where it is not possible to fully comply with the principles contained in subdivisions 1 to 8, a redistricting plan must give priority to those principles in the order in which they are listed in this section, except to the extent that doing so would violate federal or state law. And so, members, it's very important that we've read from the Constitution. We have read from the principles which have been used in regards to redistricting in the state of Minnesota in the past. And I would say, even though we go through a legislative process, which is very valuable, traveling throughout the state, taking testimony throughout the corners of the state, documenting such testimony is a very valuable part of the process. And that is an important part of the process to go to. It's a legislative duty and a responsibility. But also, it has always been the case here that in regards to the matter that comes before us, if that is insufficient, then any citizen that feels that this has brought harm to them is able to take it to the courts, and that has indeed been the case, which usually a 3-judge panel appointed by the Supreme Court then takes over the redistricting plans, and that is the current plan by which we are today as senators. We are abiding by that court-ordered plan here in the state of Minnesota currently today. So, Mr. Chair and members, that is my explanation of the bill at this time.
Thank you, Senator Kiffmeyer. I believe we have those here to testify. We have at least one listed. Are there others who are interested in testifying? Please come forward. We have a 15-minute time limit for all testimony. So please, as you come up, be as concise and brief as possible. State your name and your organization.
My name is Jim Herrick from Lauderdale. I represent the Minnesota Citizens for Clean Elections. The partner bill on this was reviewed by the House in a House hearing Tuesday of this week. There were some 20 or so people that were against it, and no one spoke for it. Principal reason is the conflict of interest that exists within the legislature to make these major decisions that tend to choose the voters rather than the voters choosing the representatives. There was a lot of discussion on the bill, but generally the provisions are seen as productive and fair, with the exception of subdivision 1B. And this is because for the last 40 years, as Senator Kiffmeyer attested to, the Supreme Court or some other body has been involved with a decision, and that is obvious why that has had to be. So we would like to continue some sort of, or see it continued, to have an outside, more credible, less conflicted group of people take a look at this. This does not violate the Constitution in that their suggestion could still be approved or disapproved by the legislature and keep that control there, but for the credibility of the legislature itself, I think you need to consider some outside counsel on this. The Chairman Anderson of the House Committee on Government Finance, looking at this on Tuesday, took a very strong stance that she felt it was important for the accountability to be held accountable in a single organization, and that being the legislature.
Mr. Chair.
And I would suggest that the accountability is seen here today.
Mr. Herrick. Excuse me, Mr.
Once the gerrymandering is and the fix is in, it's too late to be accountable.
Excuse me, Mr. Herrick. Senator Kiffmeyer.
Mr. Chair, I think as a matter of record here, we do not bring in testimony from the other body. They are not present and able to respond to those comments. It's just a rule of the Senate. We're glad to hear your own personal testimony, please. But you have a line behind you of many people.
Thank you.
So we want to
Thank you, Senator Kiffmeyer. And we do have a variety of speakers. It looks like if we, those that are in line as we have it today, everyone would have less than, excuse me, Mr. Herrick.
And I will give up my time.
Excuse me, Mr. Herrick.
That is on
excuse me, Mr. Herrick.
Section 5.
We appreciate your testimony. Thank you.
So
we have other speakers.
Very good.
Excuse me, Mr. Herrick. We have other speakers. Next speaker, please. And everyone, we have 15 minutes total, so with those in line, we have about a minute and a half. Please be concise, and please state your name and who you're with. Thank you.
Good afternoon, Mr. Chair, members of the committee. My name is Suzanne Peterson. I hail from Rochester. I am a constituent in Senator Nelson's district. I'm not with an agency or a nonprofit organization. I am, however, part of a group of activists that have been awakened lately and are looking at the various legislations, legislative initiatives in our state. We're concerned about the goal of this bill. To us, this bill is frankly unbelievable. And I don't mean to infer immediately that there's anything nefarious that's going to occur, but please understand our concern. On its face, it does appear to be unfair and unreasonable, perhaps even unconstitutional, depending upon how it plays out. We ask the question, what's the purpose of the bill? It appears to us the purpose of the bill is to put the legislators in charge of redistricting. It begs the question of why. No matter which side of the aisle that you're on, why is that thought to be fair and reasonable? Right now, if the parties do not agree, at least there's a neutral arbiter tasked with determining a fair outcome. I understand there's another bill that's going to create a different pathway. I'm not speaking to that. I'm speaking to what's currently going on. Minnesota is in the shape it is in currently because of this. Another rationale we hear is that if we don't like the results of redistricting, we can vote legislators out of office. But it seems to me the entire purpose of gerrymandering is to create safe districts, and therefore, we would not be able to vote folks out of office. There is an inherent conflict of interest in allowing legislators to redraw district lines. Surely we know this. From our read of it, it looks to possibly allow legislators to choose their voters, not the other way around. To us, this sounds like it has potential for voter suppression. Please think of it from our perspective.
Thank you, Ms. Peterson. We appreciate your time and your testimony. We have a new next testifier. Please state your name and organization, and we have a minute and a half. I'm sorry, there are a number of people in line.
Good afternoon. My name is Kathy Tomsich, and I'm a member and volunteer with the League of Women Voters Minnesota. We believe it's good policy to define the redistricting principles and procedures into statutes, and we support the principles that are in Senate File 86, but we believe there should be an additional one that says the districts must not be drawn for the purpose of protecting or defeating an incumbent. However, we oppose creating a provision prohibiting the legislature from creating an independent commission composed of non-legislators. Legislators. The history of redistricting in Minnesota tells us there is a need for reform. In 4 of the last 5 plans, they were determined by the courts because the legislature or the governor could not agree. In other words, redistricting has been conducted by a body of non-legislators for 4 of the last 5 redistricting plans. So we believe that without reform, we face a costly and time-consuming repeat of what happened before. Senate File 86 is a severe impediment to reform. Yeah. I'd also like to clarify the differences in the way commissions are formed. Senator Kiffmeyer mentioned California. Some commissions, like Arizona and California, are partisan, where the commission members are specifically identified as Republicans, Democrats, or independents. These commissions have the final say on the maps. In Iowa, there is the Legislative Services Agency, a body of civil servants committed to nonpartisanships that prepares redistricting plans. In 2008, former Governor Carlson and Vice President Mondale...
Excuse me, Ms. Tomsich. I'm sorry, but we've reached a minute and a half, and we do have 5, 6 other speakers.
I'd like to
Very
say
quickly,
one thing
please.
here. In both the Iowa and the Carlson-Mondale plan, the legislature has the final decision on the redistricting plan, and they would be held accountable for that final decision. If Senate File 86 is enacted, it would cripple the legislature by eliminating these 2 viable options for redistricting, the Iowa option and the Carlson-Mondale plan.
Thank you, Ms.
We urge you to oppose.
Thank you, Ms. Tomsich, for your testimony. Next testifier, please state your name and your organization, and you have a minute and 30 seconds. Thank you.
That's more than I need. Thank you, Mr. Chair. My name is Gary Fifield. I live in St. Paul, and I'm just going to, everything that needs to be said is going to be said by other people, so I'm just going to bring up one point. Senator Kiffmeyer mentioned the situation in California with a commission. I would speak in opposition to 86 and in favor of a commission. My reading of the situation in California is that the Democratic Party did indeed unbalance the situation with testimony to the commission. However, the Republican Party stated in the reading that I've done that they ended up with a better map because of the commission than they would have ended up with a Democratic legislature. So I think that both parties have something to gain here by the creation of a commission with the structure that's described in Senate File 370, where you will have the final say and you will not be relinquishing any of your constitutional duty. Thank you, sir.
Thank you for your testimony. Next testifier, please state your name and organization, and you have a minute and 30 seconds.
Thank you. Good afternoon, Mr. Chair and committee. My name is Shauna Crossan. I live in Roseville, Minnesota, and I'm speaking here only for myself. Thank you for hearing my perspective. You obviously have much more information about this than I do, but I would like to say that from a public perspective, this bill does appear to have a conflict of interest. And as the previous testifier said, a lot of what I would have said, what I have written, I will not go through because others will say it. I did do quite a bit of research on this, and overall my research shows weighs far in favor of a commission-based and a redistricting reform as opposed to a legislative controlled process. One interesting fact I found, according to the Brennan Center of Justice at the New York University of Law, no other country in the world allows legislators to draw the lines of the districts in which they run for office. I found that fascinating. In short, I was also confused by some of the California example offered on Tuesday. The evidence, or the article quoted, the evidence was actually from 2011, which was before any election was held, and there is definitely differing opinions on what happened in that California election. I do feel that that California example does not prove to the public, to me at least, of why a legislative controlled process is in my interest, as in a better interest for the public than a commission. So I would welcome evidence from the committee to help me understand why a legislative controlled process is better for the public. And I urge you to vote against Senate File 86 and consider instead a bill that establishes a fair and independent commission.
Thank you, Ms. Crossan. For your testimony, next testifier, please state your name, organization, and you have a minute and 30 seconds.
My name is Hunter Cantrell, and I'm from the town of Savage, Minnesota. I represent only myself. Members of the committee, I come here to testify before you today in opposition to Senate File 86. Others have already said that there is a conflict of interest inherent in regards to the legislature drawing the legislative lines. And if we look to, in particular, the 2000-2010 redistricting lines, the cases had to end up going to the Minnesota State Supreme Court. So considering that the states are the laboratories for experiment in our practices of democracy, when you are experimenting and your methods fail to yield the proper results for what you're trying to aspire towards, you end up changing your methods. So I would advocate actually for the formation of an independent commission. And I know we're not Wisconsin, but if we look to our neighbors to the east, they were actually ordered to redraw their legislative districts in late November 2016. I think they offer a good case study in terms of what can happen when you have a legislature that ends up being too heavy-handed one way or the other. And gerrymandering is not solely a Democratic or Republican exercise, but it does threaten our democracy if we allow these cases to go outstanding more so. So that's my testimony. I'll leave time for other people. Thank you.
Thank you, Mr. Cantrell. Next testifier, please state your name and organization, and you have a minute and a half.
My name is Laura Zembrunnen. I'm an engineer and an entrepreneur in Rochester, representing myself and concerned family members and friends throughout the state. I'd like to start by saying I've read the principles, I understand them, I appreciate the explanation. I'm not an expert, and I definitely support them. But that's not my problem with this bill. My problem is that I don't trust the process regardless of the principles. And that's because I've seen repeatedly what can happen when one party has control of both houses and the executive, be it governor or president. With party affiliation being where it is, principles can disappear or twist in ways I can't even imagine now. And you can reassure me that this won't happen, that our legislators won't let this happen, that our process won't let this happen. But the stakes are just way too high for me because this is my vote. I want a safety net. I want options when it comes to protecting my vote. So we should not be ruling out redistricting options that include technical solutions or independent commissions. Thank you.
Thank you for your testimony. Next testifier, please state your name and
Hello.
organization, and you have
Hello,
a minute
my
and
name
30
is
seconds.
Christine Butler. I'm a resident of St. Paul, Minnesota. I have no official title other than that of private citizen. Just a couple of remarks. It should only be a minute. In January, the Economist Intelligence Unit's Democracy Index demoted the United States from full democracy to flawed democracy. Now, they use a lot of criteria to establish what they would say a flawed democracy or establish the health of a democracy. One of the criteria that they use is how competitive is campaigning. I think it would be really easy to find in this room, and in fact in any group of people, a lot of people that would say that our democracy is suffering. At the federal level, I've been noticing, and many people notice, a growing climate of almost basic contempt by lawmakers for constituents from the other side of the aisle. We've seen it recently in Washington with legislators accusing paid protesters just because they are from the other side of the aisle. They've been refusing to hold town hall meetings, etc. Gerrymandering is a cause and effect of this at the national level. It isolates public servants from their constituents. It allows for further contempt of the minorities in their gerrymandered districts who did not vote for them. A legislature drawing its own districts is a clear conflict of interest to the point that I find it a little shocking that we're even talking about it here. We all know the system's suffering, and changing it begins at the local and state level. Legislators should not be picking their voters. Voters should be picking their legislators. Legislators should be serving the constituents they have, not seeking to isolate themselves from those with different views. As I said, change begins at the local and state level. I strongly urge you to vote against Senate File 86 and support the creation of an independent commission. Thank you.
Thank you for your testimony. And please don't forget to sign in. And then we have our last testifier. Please state your,
My name is Daniel Pinkerton, and I am a retired employee of the U of M, and I represent only myself. I have a preference for a commission, but actually, no matter which way the panel decides to go, I believe that there is one thing that I would like to stress, and that is that one criteria for forming districts that is not a part of this bill is political competitiveness. We have seen from the case in Wisconsin that, in fact, districts can be gerrymandered for more than just racial purposes or economic purposes. And we have seen that in the federal courts, it is now illegal to gerrymander to favor a particular political party. I believe that adding political competitiveness to this bill as an amendment would strengthen it greatly, and would be those of us who would favor a commission, but would see the legislature continue to do it, would be greatly relieved if political competitiveness were added as one of the criteria for drawing Senate and House districts. Thank you.
Thank you, Mr. Pinkerton. Senator Kiffmeyer, or is there any discussion? Senator Lane?
Mr. Chair, I have an amendment. I think it's been copied.
Okay. Senator Lane has an amendment. Does everyone have a copy?
No, we don't have copies.
Oh,
Oh, they're coming.
Senator Rust?
The issue of political competitiveness, in the most recent list of principles that were set out by the courts when they drew their districts, was political competitiveness one of the principles that they inserted in their findings? Ms. Stengel.
Sorry, Ms. Stengel.
Thank you, Mr. Chair and Senator Rest. Political competitiveness was not one of the redistricting principles, but from the courts in the 2010 redistricting.
Thank you very much.
Mr. Chair, I have
Senator Lane.
I have the A1 amendment that I would recommend for passage.
Senator Lane, or Senator Kiffmeyer, did you comment?
Thank you, Mr. Chairman. Mr. Chairman, this amendment, for the benefit of others here, adds another principle in regards to incumbents. The districts must not be drawn for the purpose of protecting or defeating an incumbent. And Mr. Chair, I would accept this amendment as a friendly amendment to my bill.
Thank you, Ms. Kiffmeyer, or Senator Kiffmeyer. Senator Lane and Senator Kiffmeyer has agreed to the friendly amendment. All those in favor say aye.
Aye.
Those opposed? Motion passes. Senator Kiffmeyer?
Thank you, Mr. Chair and members. I ask for that this bill be laid over for possible inclusion in the omnibus election bill, and appreciate all the testifiers and the comments that they have made, and the amendment as well. And I appreciate your time and opportunity. And with that, Mr. Chair, I know we have other business to attend to.
Thank you, Senator Kiffmeyer. Senate File 86 will be laid over for as amended for possible inclusion in the election omnibus bill. Yeah, I was got to get it back to the boss.
Senator Isaacson, welcome to the committee, and please go ahead. And just before we start, those of you who have already testified, we will only take somebody who has not yet testified on the subject.
I have prearranged that to occur.
Pardon?
I have prearranged that to
Okay, Senator Isaacson, great. Why don't you go ahead and present your bill
Well,
then?
thank you so much for your time. I'm not sure if the norms are that I should have brought cookies or something on your first time. That's what they do in the other body, but I don't want to break any rules. Thank you for taking the time to talk with me today and let me present this bill. I have to say that this is going to sound like a rebuttal, sadly, and that's not the way I intended that to happen. So with all deference to your bill, it's going to sound an awful lot like a rebuttal to Senate File 86. Right now, in the last 17 years, there have been over 400 court cases on redistricting because of gerrymandering and partisanship that occurs in the redistricting process. Right now, there are 23 states that have some form of a commission that are operating at various levels, including, as we've heard before, California. The facts of the matter is that we have demonstrated as a legislature over the last 50 years an incapacity, inability, or an unwillingness to put forth a legislative plan, a redistricting plan that does not fall into the grips of partisanship. It isn't 4 of the last 5, it's 5 of the last 6, and one of the ones that did go through, went through because a veto was messed up when it was sent over. So frankly, it would have been 6 of 6. So you have to go back to 1950. That's problematic. The partisan tension we see in Minnesota is no exception to the partisan tension we see elsewhere. And the fact of the matter is we're in a high partisan tension environment. And that's just kind of the reality of politics right now in America and Minnesota. And I think we need to take that partisanship out of the election process. I think in terms of how we choose the districts and how we set our maps has to be done by a group that doesn't have a partisan agenda. That being said, I'm very keen to what Senator Kiffmeyer had pointed out about our constitutional obligation and our constitutional duties, which is why Senate File 370 is the answer to this problem, because it in no way defies what our constitutional responsibilities are, nor does it take the power out of the legislature to finally decide. But what it says instead is that we are going to have a commission put together much differently than California of 5 appellate judges who have shown a history of not having partisan attachments that are going to make the decision on how this map should be drawn. I think that's an important thing to think about. We're already doing a version of that already. We have been for the last 50 years. And so what I'm saying is that we need to look at having a commission that takes care of this and brings us the maps to vote on. And after 3 maps, if we haven't agreed, fine, we'll take a crack at it then. But we're going to have a starting base that comes from a nonpartisan point of view. And I think that provides us with a lot more credibility. And I think it tells the people of Minnesota that we're very serious about making sure that as much as possible, we're going to take some of the partisanship out of this. When I was running this last fall, the one thing I heard a lot about from constituents from all over the map politically was you need to get the partisanship out of this business. Now, granted, it's kind of hard to do that. We're Democrats and Republicans. It's kind of the way it works. No one's so naive to think that isn't the case. But what they do want us to do is at some point put our partisanship aside and do our jobs. And so this gives us an opportunity to do that in a way that's very functional. in a way that's very prudent for what I think Minnesota is asking for. If I had had more time, I could show you some maps and give you examples of partisanship in the past. I'd be happy to do that. But I want to just take a few seconds here to talk about what this does. I'm not going to be able to go in the detail that you did, but I will say this. The second half of your bill, I'm not completely opposed to. This idea of having to set some standards so we're not reinventing them every year, I don't think that's a bad idea. It's just the front end of the bill, we're going to codify something that's already in law. I'm not sure how I feel very good about that, and I think we need some changes. What this plan does is it puts us in a position where the 5 judges are selected, and then the committee has to put together they have public reviews, and they have to put together a plan and submit it to us by April 30th of every year ending in 1. We have the choice as a legislature to enact it or send it back. We send it back, it goes back to them, they redo it, they send it to us again. We can enact or send it back. And if on the 3rd try, we can't agree with that commission, then we are the arbiters of where this is going to go, and we can redraw it how we want. My guess is we're probably going to start somewhere where they ended and fix what we think needs to be fixed. If that's our worst case scenario, then we're doing a pretty good job. And we've involved people in this process, and we have people that are excited about finally having us put together plans that work when it comes to how we draw the maps for our legislative districts. So I have a few testifiers here. I've asked them to come up and say a few words. I know time is tight, and again, I really appreciate it.
We have another committee coming in this room, and matter of fact, they're in the wings waiting, so you have 2 minutes.
Oh, wonderful. Well, then
And
I'm
by
just
the
gonna
way,
ask-
just to mention in the whole context of things, remember your other testifiers also did speak to the other bill.
Right,
So
and that's
in the
true.
That's why we put them together.
I'm going to ask the Secretary of State, Steve Simon, to come up and say a
All
few
right,
words,
sure.
and then I'll do my closing comments.
Okay.
Thank you, Madam Chair and Senator Isaacson. I'll be quick. You've heard a lot of the arguments. I would say this, 14 states have a commission. They vary, but they all, I think, have enhanced the quality of the maps and enhanced the legitimacy of the maps in the eyes of the public. In terms of Minnesota, let me mention 2 names, Roger Moe and Steve Swigum. Roger Moe, the longtime DFL Majority Leader of the Senate, and Steve Swigum, the longtime Republican Speaker of the Minnesota House. They support this concept. And when I talked to them about why they support it, they said, in essence, and I'm paraphrasing, they said, look, each side has sort of a partisan dream of what their map would look like. You know, on the congressional level, year in and year out, you see Democrats trying to push the 3rd congressional district closer to Minneapolis, and you see Republicans trying to smush together the 4th and the 5th, and that happens every decade. And in essence, they said, that dream map never happens. It always ends up in the court at considerable cost in terms of both time and money. And so if I can paraphrase what both of them think, they think it's going to end up in a court fight anyway. Let's have judges, in this case a certain set of judges, draw the maps, and then have the legislature have the final say, and even map-making authority if it doesn't work out. But their view, and they're not here to testify for themselves, but as longtime legislative veterans, is that this is the best way to go about this every 10 years. So I support the commission. I thank Senator Isaacson for getting,
Thank you.
and Senator Kiffmeyer for getting the conversation started.
Yes, thank you, Secretary Simon.
Last comment, and I'll be
Senator
out of your way.
Isaac, very briefly.
Thank you so much for your time, and I want to say this, that as we move forward, I extend the olive branch saying, I want to work with you on this. Let me know what I can do to make this bill better, to help you make the other bill better. Bipartisanship has got to rule the day when it comes to how we do this. We have an opportunity to do that, and I hope that you'll seize that moment. I assume we're laying it over for possible inclusion. Is that
Yes, we
correct?
are.
Thank you very much.
Thank you, Senator Isaacson. And the Senate file. Senator Lane, we do not have time.
One 10-second comment.
Senator Lane, we have bad weather coming. And if I allow you, I will have trouble with allowing others. Senator Lane, you said, go ahead, make your statement.
I just wanted to reiterate what I heard one of the testifiers say, that no other country in the world lets legislators draw their own districts.
All right, thank you. Because of the bad weather that is on its way or make things uncertain, we will not be returning this evening because of the weather. Do want to mention that all of these bills are all laid over for possible inclusion. And so I will mention here that The bills that will be in the omnibus election bill are Senate File 514, and this is not the language, but it gives you a sense of what we are looking at. 514, 770, 771, 772, 838, 1225, 1226, 811, and there will be language posted, but we are working with stakeholders and interested parties, so to give us the best opportunity. But all of these bills have been heard before this committee. With that, members, we are adjourned.